Welcome. We're the IAM, the Inventors Association of Manhattan, and we're here for the purpose of education and empowerment of all of you. We do that with intelligent speakers and great professional members, and encourage you to participate as much or as little as you want. Suck it all in, ask questions, what have you. So thank you for coming and for your time. We hope to repay it in a good way. Our association is supported by the members and also by various professional members who we feel are very good at what they do, act quite ethically, and provide valuable services to all of you. Just want to give a couple of them a minute or two to introduce themselves. Gordon. And any other professional members? Lewis also, yes. So.
My name's Gordon Randall Perry. You may know, some of you know me from other meetings. I'm an industrial designer. I do new product development, engineering, all kinds of stuff to get your product to ready to be sold in the marketplace. So we're very good at what we do. We're right here in Manhattan, and I'd love to talk with you if you have any interest. Thank you.
Thank you, Gordon. Louis Del Judas, also our host here at Troutman Sanders.
Good evening. Thanks for everybody coming by. It's always a pleasure to sponsor the organization. I'm a patent attorney by trade, mechanical, electrical, so for most inventions you guys have, I can be of some help. If you have any questions about the process, patentability, how patents work, here or abroad, I'm available. We have other patent attorneys in the group as well, and I'm sure you're going to hear from one tonight, it sounds. So at any time, feel free to stop by, give me a buzz, and I can hopefully direct you in the right direction. Thank you.
Thank you, Louis. And Josh Dubrow, who is one of our speakers this evening from the CPA firm of Nussbaum Yates, Walpow, Klein and Walpow.
Nussbaum Yates, Berg, Klein, and NYBKW. You don't have to worry about the names. I'm Josh Dubrow. I'm a CPA. It's my pleasure to get away from my desk for a few minutes on my last week of tax season. So, especially on this beautiful day. So, I'm happy to be here. And as Bruce said, I'm going to be speaking a little bit about some of the pitfalls and the common mistakes that new businesses and startups make, and a lot of times find out a little bit too late. So we'll talk about that in a little bit. So it's great to be here.
Thank you, Josh. And with that, I'd also now like to introduce you to Amy Goldsmith from Charter, Krinsky & Drogan. Amy is a intellectual property attorney who I've known for a number of years, and I think you'll find her comments, not just about patents, but about other legal matters, quite interesting. Amy?
Yes, thank you, Bruce. So, I'm really pleased to be here. I love to lecture. I do it a lot. So, the first thing that I always say is, please interrupt me, because it is more interesting when you ask the questions. So, last week, as Bruce knows, I did a version of this lecture, and I was able to hand everyone out some Play-Doh. And I asked them to form something, make something that came from their imaginations. And they did, and it was quite interesting. I think the most interesting was the black cloud, because we had been talking about the cloud, and I had given him some black Play-Doh. But I want you to think, now you're all in the invention space, so I want you to keep in your mind your inventions, your brands, what you've created while we go through this process. So, talking about brands. First thing that you should really be thinking about when you invent something, when you create something, is your brand. How are you going to be known? What is the message that you want to portray? And is that brand available? Many people come to me and they already have their brand, they already have their messaging, and I say, did you clear it? And I get this, clear? What's that? From people who are very sophisticated. So it doesn't matter how long you've been doing this. If you haven't been speaking with the right people, your whole strategy may not work because someone else has registered your brand. So even if you do your own search, and I know a lot of you are very entrepreneurial, you're going to go on uspto.gov and you're going to pop in your name, and you're not going to find it, and most likely you'll say, oh, I'm home free. I can go ahead and do this. That's not really true, because uspto.gov is only the first step. And if you're not inputting the search correctly, you may not find something that's relevant. There's something that I like to call the Ralph Lauren issue. The Trademark Office, in its inimitable wisdom, has said that, let's say you're filing an application for a mark, let's call it XYZ, and you're filing it for cosmetics. Let's say somebody else has the identical mark or something substantially similar for apparel. Well, guess what? The Trademark Office is likely going to bounce your application because they look at it as everything within the Ralph Lauren space. If you go to Macy's and you see Ralph Lauren and you see they have linens and they have apparel, and they have cosmetics, and they have a whole bunch of other things, they're going to group that together and say that it's going to be confusing for the public for that brand to be yours and Ralph Lauren's. So the search has to be wider than you may ordinarily think. And it doesn't only include what's on the register. Unlike many other nations, almost all of them in fact, we run two systems in this country. We run a registration system and we run a prior use system. So if someone in North Dakota has used XYZ for cosmetics and they've had a little bit of interstate commerce, well, guess what? Even if you get a registration, they can challenge it. So if you're just looking on uspto.gov, you're not going to see your friend from North Dakota. If they don't have a website, you're not going to see your friend from North Dakota. So what we recommend after you have this POP clearance search is to do a full search. And that full search gets us everything. Now we get it online, but we used to get this big book, 500, 600 pages that we go through. And it's got everything about XYZ in cosmetics and in all these related fields. Not only registrations, but what we call common law uses. So we'll find that person in North Dakota. We'll find the domain names. We will find those little companies. We will find everything that could be a potential problem, a potential risk for your brand strategy. So you find the brand, you do your searching. For not that much money, you're set. Rather than 6 months down the road, you've got your website up, you've been selling product, and you get a cease and desist letter in the mail. And really, your attorney says, sorry, but there aren't very many defenses that I can offer you. You're going to have to change your brand strategy. That's not a good thing because you've spoken to your accountant and you've set up your budget. And you set up your budget for a little bit of extra, allocation, hopefully, but you didn't set it up for this because they may want some profits, they may want some damages. Yes. So clear it.
So with the
Spend the
concept
money
of
up front.
With the concept of a checklist then, Amy, what you're saying is that the first thing is the brand and the name that people should think about.
Absolutely.
Once you're down the path of commercialization or as you're thinking about that.
Yes. So you've got to clear your brand. Yes.
Is the only way to do that, what do you call it, a poll search?
A full search.
Full search.
Full comprehensive search.
And only an attorney can do that?
No, you can go and order it directly from one of the services. The question is, are you sophisticated enough to know what you're reading? Because if you're not practicing in this area, you're not going to know whether the Trademark Office is likely to reject an apparel application on the basis of a prior cosmetics application or any of the other services. Are they going to reject your entertainment brand because someone has a TV show? So without the depth of experience, I understand everybody wants to save money, but penny wise, pound foolish.
Just as a follow-up question, you said it's not too much money. Is there a range?
The services typically charge about $600.
Okay.
But that's our discount, so I'm not quite sure what they would be charging, just
Full
a one-off.
retail.
Full retail, exactly. Yes.
So really there are two searches that we need to do. Number one, we need to do a search on the actual idea.
We're going to
first.
get into that.
Oh, okay.
Yep, we're just talking about the name.
We're just talking about the name or a mark or...
Yes.
Okay.
So what kind of marks are you likely to get cleared the most easily. Okay? They're not cosmetics for cosmetics. Okay? We're not talking water for water or table for table. Those are all descriptive. You can't protect them. Everyone in the universe can say, I'm running a table company. You want to start off with something that is really unique. So what do I mean by that from a practical standpoint? The best types of marks are those which are fanciful. Fanciful meaning no one has it. It doesn't mean anything in any known language. Xerox. We all know what it means now, but that's because of their marketing. When Xerox came by, people were, Xerox? What's that? You know, so you want to choose something that is unique to you, that is creative, and rely on your marketing strategy to impute your idea to that brand. Then, likely, you're not going to find it on USPTO.gov, you're not going to find it in North Dakota, you're not going to find it across the river in New Jersey. It'll be yours uniquely, and your brand strategy can be built around it. Okay? Let's say you can't come up with it. I mean, face it, not everybody is creative. Then you look down and you go for an arbitrary mark. Apple, a very, very strong brand, is an arbitrary mark. Apple means something, okay? They hang from the trees and you eat them. Doesn't mean anything with respect to computers, so it's an arbitrary mark. Going down, we have suggestive marks. Suggestive mark is Windorama. Window, okay, you think it's got something to do with windows. Maybe it's cleaning windows, maybe it's installing windows, maybe it's creating new kinds of windows, and the Rama part is very arbitrary. I think it means something in Hindu, but I'm not sure what. And the government will translate that. So you can't go to your dictionary, find a word in a foreign language like ventana, which means window in Spanish, and say, oh, I'm going to be the Ventana Window Company. No, doesn't work. Doctrine of foreign equivalence. They want you to come up with something novel, something unique. So, step one, find your mark, make it as unique as possible. It can be suggestive with respect to what you're doing, because I've been doing this for a long time. Everybody always comes in with either descriptive marks or suggestive marks. Very rare that someone comes in with an arbitrary mark or, even best, a fanciful mark. It's not easy. It requires a lot of thought, and there are very many companies that peddle their services to do this for you. Yes?
Where's the tagline to that?
A tagline is protectable. You're in good hands with Allstate. Completely protectable for their insurance services. A logo mark, like Nike's swoosh, completely protectable. Don't use it. Don't use anything that has anything to do with the swoosh.
They'll come after you.
They will come after you. I had a case where Nike came after our poor UK client coming into this country for lathes. A lathe, it's a woodworking tool. And Nike has absolutely nothing to do with lathes, but they came after my client because they had this swoosh. Yeah. So if you're even if you're coming in from a foreign country, you have to search it here. If you go to another country, you have to search it there, because we're running territorial systems here. What you register in the US is not good over the border in Mexico. It's not good up in the Canada. You have to register in each country, you have to clear each country. And you have to think about this when you're tiny, because if you get huge and you want to export your products, are you going to change all the packaging? No. So, let's say you've come up with this fantastic brand, you've searched it, it's clear in the US, it's clear in the nations in which you're going to manufacture, and it's clear in the nations in which you want to export. So 3 steps here: clear US, clear manufacturer nations, very important, especially China, and clear where you want to sell. You've got a priority period of 6 months. Let's say you file your trademark application April 1st. If you file your application in a foreign country by October 1st, they're going to give you priority. So it's as if you filed it April 1st, which is great, Because if you've got an unscrupulous manufacturer on the other side of the table, and you disclose your whole plan, and that manufacturer ran off and filed, well, you're gonna predate them with your April 1st date. And that's very important because almost every other country is running a first to file system. So you can be exporting $1 gazillion worth of products to that country. If your manufacturer has registered the mark first, especially if it's China, you're going to be spending a lot of money to try to get that mark back. Yes?
Do you have, if you do not register it within that 6 months, and let's say a year, 2 years goes by, do you have the opportunity to file in another foreign country?
You have the opportunity to file. You will not receive priority, and if somebody else got there before you, you're going to be spending a huge amount of money to get your mark back.
But if they didn't get there before
If they didn't get there before you, you're going to be okay. But it's very common. I've got a case now against a Chinese entity that has applied for, I think we're up to thousands of other people's marks. And it's blatant. It's not as if these marks are something like cola. Okay, these are distinctive, unique marks that this company has applied for. China will not bounce them.
How much is
Okay.
a registration in China?
It's about $1,200. Yes, for one class. And they start charging after you've exceeded 10 items. So let's say you want in one classification. So let's say you're in class 25, which is apparel, and you're selling t-shirts and shorts and tops and shoes, and you've exceeded 10. They start charging and charging and charging. Why is it important to be as comprehensive as possible? Because in China, let's say the mark is XYZ and you've applied for t-shirts. Somebody else has applied for XYZ for tops. If tops don't appear in your listing, China won't reject that other application. And then it's going to cost you a lot of money to get it back. So if you're going into China, you really have to think of your strategy and have to allocate the proper resources to your offense, because you have to start that at the very beginning.
But not to scare everyone, if you have no intention of selling into China,
Or manufacturing there.
well, if you manufacture there, you still can prevent people from coming to the U.S. with you.
Yes.
Right.
You can prevent people from coming to the U.S., but my philosophy is forestall everything at the very beginning, allocate those funds at the very beginning if you're going to be manufacturing there, because it's a cesspool, honestly, with respect to their IP system. Most of our infringement, most of our counterfeits come from China. This is not only an issue with respect to tops, this is an issue with respect to batteries. Okay? Batteries, counterfeits. Is that Duracell really a Duracell? It may not be. Yes?
So I was trying to say they set up 3 complete Apple
Yes.
stores,
Yes.
and not one item was Apple.
Right.
And people were going and thinking that they were buying Apple products, but it was just fictitious stores.
Yes. And they did a very,
And
very
they did
good
a very
job.
good job.
Yeah. Now, the Chinese government did
Oh.
stop them. They did shut down those 3 stores. Why? Because Foxconn is in China and makes a lot of the Apple products. So there was an interest there in keeping Chinese workers. Yeah. But yes, and the philosophy is different. It simply is. And if you don't follow the rules of their system, you're going to pay for it in the end. So if you're going to be in China manufacturing or potential sale, because it is a good market, people do have disposable income there, and they love brands, then you're going to have to allocate the funds to protect it. It's not that much at the very beginning if you're in one classification, about $1,200. So it's a fortune to try to get your mark back. Even if you're a huge brand, you will be fighting for years, and that's not where you should be putting your resources. So, just a note. With respect to foreign protection, again, just to sum up, you want to clear the mark in the foreign country, and then you want to register in that foreign country. Now let's say it's 5 years down the road, and your business is doing really well, and you haven't registered in some countries in which you want to proceed. then that's the time to see if it's clear in that country and to file. And we can file in many countries now on an international system called the Madrid Protocol. So it's a lot less than it used to be. We don't have to go through foreign lawyers. We can go through the Madrid Protocol, rely on your US registration, and proceed that way. So there are mechanisms, but again, you have to make sure you've got the budget for it, because not doing it can have a very negative effect. Yes?
What's the danger? This is a new fact to me that you have, if you manufacture in China, that you should register your mark there. I didn't know that. What's the danger? I mean, let's say you make a cola product or XYZ, and you're selling it here, not selling it there. What might happen?
They can open up a website under
Oh.
your brand, and you've got instant confusion.
I see.
So
I
it's
see.
not only...
Now you made your point.
Okay. Yeah, so you've got to think, and that's another reason why we do these full searches, because we get all of the domain names and we see if those websites are active. So it's a broader business approach to branding. Yes, Patrick?
Does it also apply to social media presence, so a LinkedIn page, and because I hear that's, I mean, do the searching tools go down there as
Yes, the searching tools delve pretty deep. So the report that we get will show all of these uses, and we'll have to determine if it's a problem. Again, it goes right back to choosing the brand. If you're choosing a really unique brand, likely I'll get a search that's like this. If you're choosing a brand that really means something, we're going to look through several hundred pages. So it all comes back to your brand strategy from the very beginning.
Patrick, that's a really excellent point, because we had a client last year who has an international-based product, and they are very serious about it. They recently closed on a significant funding event. But they took a chunk of what they're doing for all their IP protections, but they protected or went out and immediately created a presence or grabbed their domain in 42 different social media sites worldwide, because they wanted to make sure they control that mark.
Yeah. I mean, what some of my clients do who have gotten into problems and they can't, you don't have the money to buy everyone out. I mean, that's a strategy. If you've got a large enough budget and you're funded, you buy everyone else out and you deal with the issue that way. If you don't, then you use social media to push those other listings down. You want them on the second page, because most people are not going to go to the next page, they're going to look at the first page. So you use your SEO so that you are on the first page. And you have to, but that's not just once, that's a continuing strategy so that your brand is top of mind and top of page. So, and the other thing we haven't spoken about is how many domain names do you actually get? Because you've got all of these country extensions. Do you go out and you get all of these country extensions? Do you just concentrate on .com? That's another consideration, because it does start, even though they may only be $10 initially, that $10 is going to multiply depending on how many extensions that you choose to buy. So these are all strategies, and yeah, it has to be an integrated strategy. You can't just consider branding separate and apart from everything else. It's got to be integrated within your business and integrated with your marketing strategy. And most marketers, honestly, I've dealt with a lot of marketers, they have no clue about this. Really. Even the most professional ones will come to me and say, oh, but of course this is okay. And I'll have to say, oh, but of course it isn't. And then you've blown whatever money you've spent on your marketer. So just be careful, be wise, and take these steps for what they're worth. You do not want to invest into a business and have your brand strategy blow up because of a cease and desist letter 6 months, a year down the line. Now what happens from, yes?
I just wonder how much more difficult. I never even considered getting the other extensions for countries. Is that a lot more difficult?
It's not difficult at all. It's
No.
just a question of whether you want to pay the money and keep them up every year.
So it's the same process as getting
Same
common org and
process.
everything?
In most countries. In Asia, you actually have to have some sort of a presence there. So you can't just get .cn. There are some other issues, but in most countries it's more open. Yeah. Yes?
If I'm at an early stage of development, I'm just filing a patent application kind of thing. And my goal is to license my product. Should I still pursue a brand and you know, that whole thing, or just leave that to whoever is licensing?
It depends on your licensing strategy. If it's mainly the product that you're licensing and not the brand that you've developed around it, then yes, the brand is not as important. It's called private label. So you are manufacturing or providing the information for another party to manufacture your product under their brand.
Right.
So that's a private label strategy, and in that case, as long as you're cleared from a patent perspective, you're fine. You don't have to be as concerned about brand strategy for the product. However, you do want to develop a brand strategy for yourself and for your business. You don't want to just be known as Joan or Jane Schmo. You want to have a persona that is real, so that if this other company is doing its due diligence, they're going to see you. I had an issue where someone brought something to me, it was very interesting, and I started doing my research, and I didn't find anything online about this particular matter. And I had to talk with other colleagues about it. And the first thing they said was, are you sure this is legit? Because we don't find them on the internet. So it's not only a case of a brand strategy, it's, are you credible? And these days, you may not be credible if you don't have your own online presence. So it's not only what you call the product, it's what you yourself, what brand strategy you have. So procedurally, what happens in the trademark office when you file? They sit on their hands and their feet and every other appendage, and they wait about 6 to 8 months before they evaluate your application. So you will not know whether the trademark office says yay or nay or fix this for 6 to 8 months. Another reason why you want to do a good job at the very beginning, and you don't want to have a rejection 6 to 8 months down the line. Now, how do you do this? Didn't used to be when I started out. You had to file just a use-based application, so you had to use the mark like this, Poland Spring, which, by the way, doesn't come from just Maine anymore. If you look on the bottle, they were bought out by Nestle, I believe, and now it says only from carefully selected natural springs. So, little fact I learned last week, could be from natural spring in New Jersey.
That's an oxymoron.
Yeah, a little bit of hero, I want to make sure you're paying attention. I have family in New Jersey. I'm just making a little New York-based joke.
Sorry, New Jersey.
But you know, you want to make sure that everything is good so that you won't get a rejection from the trademark office. But the process does take some time. It's 6 to 8 months. Now, you can file based on use, which is what it used to be, but you can also file now based on intent to use. So if you have your brand strategy, but you know you're not going to be pushing these products out or having these services up for another year, you file, you gain that priority date when you file on an intent to use basis. And that's the way the rest of the world works, actually. You're filing on an intent to use basis, and in the rest of the world, you're getting your registration even before you've shown use. It's reversed in the US. You can't get your registration here unless you show use. So you file based on an intent to use. You basically, once they allow it, will have 3.5 years, but you have to pay them every 6 months for this privilege. Yep. And then you'll get your registration upon use. Foreign countries, you're going to file, you're going to get your registration, but if you don't use it in those foreign countries, then a third party can challenge it because of your non-use. They give you 3 years after the registration issues to use the mark. Otherwise, you're vulnerable. What we typically do with clients that have a big foreign portfolio that's important to them, let's say they wanted to be in Brazil in 3 years, but they didn't quite get there, and now their registration is in that vulnerable point, we'll refile. The other one will be alive, but we'll refile just in case someone petitions to cancel based on non-use. Everybody get that? Okay. Any other questions with regard to trademarks? No? No, you're a quiet crowd tonight.
You're
Okay.
thorough.
Thank you.
Yep, you can take that for what it's worth. What happens after the registration is issued? Has anyone seen a TM or an R in a circle? Okay. Do we know what they mean? TM means trademark. It's what you use before your registration issues. R in a circle is what you use after your registration issues. Now, many attorneys will send out a cease and desist letter, and they'll say, you infringe, give me the money. Come on, I want all that money. And I'll do an investigation for my client. And what am I looking for? I'm looking to see if that plaintiff who owns a registration has actually marked their product with the R in a circle. Why am I looking for that? Well, buried in the US Trademark Act is a provision that says, if you don't use the R in a circle, you don't get any damages until you've notified the infringer. Then your damages clock starts ticking. Tick, 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 tick. So if you don't put the R in a circle on your products or in connection with your services after your registration is issued, you're just shooting yourself in the foot, because you won't get damages and you won't get lost profits because you haven't marked. Yes?
Other than telling the world that you have filed or hold it out as your mark, does the TM impart any notice?
No.
Officially?
No, it's an unofficial term. It does serve a marketing purpose, and marketers are the ones that are most often at fault here. They don't understand the significance of the R in the circle. They don't like the way it looks. From an aesthetic standpoint, it doesn't look nice. So they say, oh, don't worry, you don't have to use it. And that's just plain wrong.
Stupid.
You do have to use it. Yes, it's stupid, but I was not going to be as pejorative. You do need to use it. You need to use it on all of your products. Now, if you ever lose your registration, you need to take it off, because that would be fraud. But you do need to use it on all of your products. You need to put it on your website. If you're rendering services, it needs to go on your brochures. It's just a little tiny R. Nobody's really going to notice it. It's not going to destroy the aesthetic. Yes?
Receiving a patent, though, is not the same as registering.
Receiving a patent, we call it a patent has been issued.
A patent has been issued.
And at that point, you definitely want to mark with your patent number as well. You've got the same standards.
So the R in other words, I mean, the terminology here is, I'm just trying to wrap my mind around it. So trademark, I understand when you have a mark or you have a name.
Yes.
But that's not, but the registering, the R, really pertains to
your mark has been issued as a trademark registration. You get U.S. trademark registration number.
Or as a patent.
Patent's slightly different. The patent, which is protecting the concept or a method, you want to say U.S. patent number. And the reason to say that is the exact same as with respect to a trademark. So you're not going to have to, basically you gotta listen to me and Lewis on this, not your marketing people, because it's dangerous. I mean, I responded to a cease and desist letter just the other week saying, all right, we've agreed to stop, sorry, we were bad, mea culpa, but we can't offer you any money because you didn't mark any of your products. I went through the catalogs, I went through all their products, nothing had been marked with anything. I never heard from the guy again.
To that point about who to listen to also, don't listen to your friends who say, oh, do this. I had a client a couple of weeks ago, and he presented some beautiful sketches, and he had patent pending on the sketches, and he had no patents filed. Yeah, so that's illegal?
It's, yeah, under the Trademark Act, that's false misrepresentation, but nobody's ever going to call you on it.
But he thought he had protection because he was using patent pending. Because his friend told him to do it.
Yes. And friends and family is a really good place to go right now. I'm just going to go over some corporate concerns very quickly. Yes?
So when you get a name for your company or a product, you got to trademark it, but it's not legal unless you register it?
It's legal because we're running two systems. We're running a prior use system, but you don't get the benefits. If you had to go into court and sue someone else based on their use of your trademark, you will have to prove use in each individual geographic territory in order to succeed. The registration gives you nationwide rights to the mark, even if you're not technically using it in every single state of the union. So you need to do, yes. Mm-hmm. Yep. Now, corporate concerns. Let's say you've got this great business concept, you've got your branding strategy, you know, you have the people behind you. What's the next step? So Josh is going to go into this a bit. I'm not going to step on his toes.
Step on as much as you want.
But my first question is not legal to you. My first question is emotional. If you have a partner, whether that partner is going to be a member in an LLC or a shareholder in a C corporation, ask yourself, can you work long-term with this person? You're entering into a marriage. Can you work long-term with this person or persons? Because, you know, majority of you are not going to open up a Fortune 100 company right off the bat. These are intimate relationships with your partners. So the emotional comes first. The legal stuff is second. So that's question one.
And I would add, when she says emotional, think absolute worst case. Say, think in your head, what's the absolute worst case thing that could happen here? And if you're okay with that happening, then maybe it's okay to go forward. If you're not, then maybe it's time to stop.
Yeah,
Because the worst case, more often than not, once business and money's involved, that it rears its ugly head. So
we had brothers because of business disputes and trademark disputes and strategy disputes that didn't talk to each other and were suing each other. And for me, I find that tragic. So choose your partners wisely. Emotion comes first. Next, have you outlined your duties and responsibilities? I'm not talking, again, from a legal perspective, although that will back into your operating agreement or your shareholders agreement, whatever structure you choose. But have you thought about who's responsible for what? Because misperception causes most of the lawsuits in this country. People don't take the time to sit down and say, okay, I'm going to do this, you're going to do that, and write it down. Yeah, we'll write some of it in the agreement, but not all of it. Because it's going to change. You're going to have to reassess every 6 months. What do I expect you to do? What do you expect me to do? So that you're all on literally the same page. Because expectations can kill a business. Next, have you outlined your strengths and weaknesses? If you say, I'm going to be responsible for marketing, but you hate it, really not a good thing to opt for. Try to be realistic about it. Who can do what most effectively? And really try to push your ego aside. This isn't about ego. This is about how to build the business. Two very different things. Have you linked those strengths and weaknesses to everyone's duties and responsibilities? Most people, again, don't go through this emotional thinking. You may have been great friends in college and fantastic roommates, but is a business relationship really going to work when, your best bud loves to spend money like water and you want everything documented? You have to really think about how that works in practice. Now, from the operating agreement or shareholders agreement point of view, again, these will back into it. An operating agreement is for an LLC, a limited liability company, and it says how you operate. A shareholders agreement is for a C corporation, just a different legal structure, and there are tax reasons to use one or another depending on your particular circumstances, which I'm sure Josh will go into. But the agreement, from my perspective, is very similar. You have percentages. Who's going to own what? Membership interest, shareholder interest. Are you going to require capital contributions? That means money. Or are you going to require equity contributions? Say somebody wants to back out. The most important thing to talk about when you want to draft the agreement is your exit strategy. Let's say someone gets ill or is disabled and can no longer perform their function. Under what circumstances are they going to be able to pull out? Is the company going to automatically be obligated to buy their interest? Will the company have enough money to do that? It sounds great at the beginning, to say, yes, the company is automatically going to buy out their interest. But that could sink the company, depending on how much capital that party put in. So these are all checklists we go through with our clients. It takes 2 hours, so I'm not doing it with you now. I'm just trying to give you a high-level overview of some things to think about. But this is, how you really want to think about it from an emotional perspective first, a legal and tax perspective second. Because the most important is working with this person or persons. And your extended family. Let's say that the operating agreement or shareholders agreement has that membership interest go to that person's family member. But you hate her husband. How can you work? You love her? There is absolutely no way on earth you're going to be able to work with her husband. It's not happening. You've got to think about this at the very beginning. So it's not only about you, the two of you or the three of you, it's about your extended world as well. And I bet you not many attorneys have talked to you about this in this way, because it's not common. Most people just drive with the standard questions and don't think about the real business aspects and the back end. So you want to make your business work. You want to be successful. You want to grow it. It's not going to happen unless you have the right people behind you. Are you going to become employees of your own company? Well, if you are, if you're with me, you're going to want an employment agreement with the company, because that's going to set forth your duties and responsibilities to the company, which is a separate legal entity apart from you. You may think you're the same entity, you're not. And you want those protections as well. Dealing with a situation right now where there was an investment made into the client's company. A couple weeks later, the client goes up, she can't get into her own company. The investor locked her out. Someone they thought they trusted. The operating agreement and shareholders agreement are not what they should be. I was just called in. I did not draft these documents. And she's been in quite messy litigation that has gone nowhere, and she's spent a fortune for the last 2 years. So she's been locked out of her own company. These situations happen. She's not an unsophisticated person. This was a several $million-dollar business. So you've got to be careful. Yes?
Regarding employment agreements, not necessarily with the new company you start, but if you're currently employed. Oh, you're getting there, okay.
Yeah, so if you're currently employed, you've got to make sure that you are allowed to open up this new business. Is there a non-compete? Is there a non-solicitation? You say, oh, it's fantastic, I'm going to leave, I'm going to pick Jerry and June, and they're going to come with me. Not so fast. That employment handbook that they handed you at the very beginning may say, you're not allowed to leave, and if you leave, you can't compete with us for 6 months, and if you leave, you can't take June and Jerry with you. So that's another thing. Do you want that in your operating agreement, in your employment agreement? If your partner decides to leave, do you want him or her to be able to compete with you? Do you want to put a non-compete and a non-solicitation in your documents? So when you're working with another person, you have to think about all of these various issues. And people get uncomfortable. They typically don't want to consider these issues at the very beginning of the relationship. It's the honeymoon phase. But you really do have to consider what happens when you exit, because it could destroy your business. Any questions? Yes?
I'd like to hear your point of view about what an inventor would need to look at in their current employment agreement as to whether or not the employer has any claim over your intellectual property.
It's very common for large employers. It's not so common for smaller employers to put that clause in their employment handbook. So if you work for a large employer, you're going to want to look at all the documents that you signed. And if you don't have them or can't find them or whatever, you can ask your HR manager for copies of all the documents that you signed. And then you're going to want to look at their intellectual property and inventorship section. Very common for them to say, well, anything that you make while you're here, if it has something to do with what you do for us, even if it's on your own time and you're thinking about it when you're in the shower or swimming or walking or running, that belongs to us. So we're paying you, so we own you. We own the property of your mind. If it doesn't have anything to do with what you do, let's say you're a financial advisor and you've come up with a great method, for analyzing your client's financials. Well, that's going to belong to the financial company you work for. But let's say you come up with a new toaster. Typically, there's going to be an exclusion that says it doesn't relate to any toasters that you may have developed. But you have to make sure that that language is proper. Typically, it's quite overbroad. So, and these non-competes and non-solicitations, they're valid in our region. They are not valid in California. So if you work for a California-based company, it's possible that even if they have that language in there, that it may not apply to you. The law's a little quirky where that's concerned. If you live or work in California, it absolutely applies. So there's no non-compete there. It's against their business and professions code.
Any options?
Patrick had one, maybe you can.
Yeah. My question was I had heard that it's not quite enforceable, but you're not allowed to prevent someone from earning a living, or I was told also that these overbroad interpretations that, we're a consumer products company and therefore any consumer product you come up with, that apparently the company would not prevail with language that broad.
Overbroad language usually does get whittled down.
Right.
But typically, let's say if you're a product manager of a division in a consumer products company and you go to a competitor and you're a product manager of the same consumer products division in competitive company, that will be enforced. If you're going to be a product manager and it's some completely different division,
Inventions, though.
with respect to inventions, it's the same. Again, the analogy is the language sufficiently restrictive to what you do for the company? That's the kind of language you want to see. All right? However, there could be situations where you come up with something that relates to another division of the company, even though you're not in charge, and that's going to be litigated, whether or not it's overbroad.
You have to be able to afford the litigation.
Oh, yes.
Yeah, gotcha.
Yes.
Any options other than quitting?
Negotiation with your current employer. Sometimes if you come up with something truly fantastic and it's a wishy-washy, not so sure situation on either side, your employer may actually, and especially if you have a good relationship with them, want to work with you. I have a case like that right now where I represent a client. We filed a provisional application for him last year. It's coming up for the utility application, which is a lot more expensive than your provisional. And he's interested in making something of this. He disclosed it to his present employer, and they're interested in making something of this. So they're probably going to help him out. So there'll be a win-win situation there rather than a lose-lose situation.
I've seen that too. I have a client that came up with something, and rather than go through the conflict, the employer, who's a relatively large company, said, "Hey, we'll be your investor. We'll back you, and you run with it. We'll fund you, and there you go." And then now they're making a lot more than they were before.
Yes.
But I'm just curious, the opposite. Let's say that they disclose the invention, and let's say the employer is not keen to do this. Therefore, because you've come up with the idea, and therefore you do quit, can they come after you?
Oh yes, if you have an enforceable agreement, and even if you have an unenforceable agreement, they can come after you and make your life miserable, which is why you really want to reevaluate this. It's not, don't just sign whatever the employer gives you. Read it. If you don't understand it, call somebody up and get them to evaluate it for you. It costs a lot less at the beginning than it does at the end. And this litigation is interminable. They're most likely in state court. State court takes a long time. You're not necessarily assigned to the same judge throughout the case. I mean, even if you're in a commercial part, it is torturous, and a lot of your energy is going to go into that litigation. So you really want to do it right at the beginning. Now, going quickly, how many minutes?
You have 5 minutes.
Oh, okay. Sorry, we're going to really short shrift patents, but I suspect that this group knows more about
give you
patents
10
than
for patents.
most people do.
Question.
Yes, absolutely.
What if you invent a product and you have it manufactured in the U.S. and it's flowing nicely, and then someone from China comes over and goes, that's a nice product, and you don't have a patent in China or a trademark in China, can they take your product and have it manufactured over in China and hit the market and blanket the whole entire market?
Do you have a patent here?
Yes, if I would have it. Okay,
Assuming in this
right,
hypothetical
assuming, right.
that you have a patent here, you can, and someone else was exporting a product that was identical to your patented product, falls within the claims, then what you can do is file an action before the International Trade Commission to stop, to block the exportation from outside the country into the country. It's an expensive procedure, but it's a rapid procedure. They really move in about 6 months, start to finish, to block it. So if it's financially worth it, you will file a complaint before the ITC to block the importation of that patented product. Now let's say it's a trademarked product or a copyrighted product. You record that with customs. So you can record your trademark with customs, you can record your copyright with customs, and customs will watch it for you. And if you know that someone else is bringing that product in, you can tell customs about it, and they'll look for it and stop it. They'll seize it.
Give us an idea about the range of what we're talking about here to block a product from coming.
Well, ITC actions can be expensive. They are just like litigations.
10,000, 20,000, 5,000?
Multiply that by a factor of 10.
Okay, 100,000.
Yeah,
I see.
and that's an easy case.
Okay.
Jewel,
Yeah.
another point though, with what you're saying, people taking it to China.
Yeah.
I would say in most instances, it's an unscrupulous importer here that has a business entity here that's taking it to China. And you can also have recourse directly against them for selling your patented product. So it's not always China. You know, that's where it's originating, but the importer is taking it to China, having it made cheaply,
Right.
and then he's importing it back here. So, you know, you have to look at it case by case.
Yes, very true. Yeah, so ITC litigation is expensive. Recording with customs is not. You're talking about around $1,500 per, again, it's always per trademark registration, per copyright registration, and you have to re-up that every few years. But it works. Believe me, customs does not want counterfeit goods or even copied goods in this country. They want to do as much as they can to stop them. In fact, I think one of the news channels had a whole report on Canal Street.
I saw that, yeah, it was on
Yes.
yesterday, yeah.
Mm-hmm. Yes, this week. Because, again, it's not only consumer products. You're talking about batteries that can be dangerous, computers that can be dangerous, drugs.
Yeah,
Pharmaceuticals is a huge issue. You may be getting a cancer drug, and it's, you know, it's just doesn't work because it's not a drug. So it's so it's a huge issue, not from a plastic bottle perspective, but from a health perspective as well. And that whole sheetrock issue a couple of years back, where the sheetrock that was put into houses was falling apart. So it's a broader issue. Yes.
It's also my understanding that when it comes to the bigger retailers, they run their businesses when it comes to this rather ethically. And if you tell them that this is, you know, that they've bought something that is infringing on your patent, they will walk away from it. They will help you.
In some cases, yes. The problem is that they are also beholden to cheap manufacturing. And they've gotten used to it, and their whole profit margin, which is very, very, very slim, is based on cheap manufacturing. So it's an issue with bringing manufacturing back into this country, as Bruce is an expert on, because you can source it more cheaply outside. And their bottom line interest may not be aligned with the intellectual property interest, and they may fight you on that ground alone. Really
Case by
depends. It's case by case. It depends on the company and on their standards. And even if a company has ethical standards, you've got to have someone on the ground in these nations monitoring their processes and procedures all the time, as the tragic fire in Bangladesh illustrated. That factory had been monitored. You know, they had visited that factory, all the big guys, every few months. But when the backs were turned, the doors got locked. So really requires, if you're going to be a large manufacturer, somebody in country, on the ground, evaluating, and not someone who has a vested interest in what's going on the ground level in that factory.
Amy, could we move on to patents?
Sure.
Because, we haven't even touched upon that.
Okay, patents, very quickly. Law changed March 15th. Patent Office got a zillion applications on March 14th, overloaded. Luckily, the system did not crash. I was sort of expecting the system to crash, Louis. I don't know about you, but
I had a pool box.
Yeah.
Actually, on it. But luckily it did not.
yeah, I mean, we were up a lot that prior week. So the law changed. So if you want to file something now, we are no longer on a first to invent system, which is what we were practicing since 1789. It's only 224 years. Why muck with it? But it wasn't my call. It's first to file. What does that mean for you as small inventors? It means you've got to have all of your little ducks in order before you file a provisional application. And that provisional application has to be filed maybe a bit earlier than you would have otherwise filed it. Provisional application, that's the worldwide placeholder. Doesn't get examined, you file it, it's kept secret for a year, but you must follow up in a year and file your full-blown US application and your foreign application. Otherwise, you lose the priority. If you don't publish in the US, you may still be able to file, but I wouldn't advise it. And in foreign countries, definitely not. So it's a first to file. So if somebody down the road has this same idea and you don't run to the patent office fast enough, guess what? You lose. So you can't sit on your invention anymore. You have to do it right from the very beginning. What does that mean? That means in whatever media you choose, you keep an inventor's notebook. From the beginning, that concept came into your head till it's as done as you can make it. You want to record everything about that invention. Not only your successes, but most importantly, all your failures. Because what the patent office is looking at is novelty. How new is what you've done? Even if it's a modification of something that went earlier, which is perfectly patentable. How novel is it? How not obvious is it to one skilled in the art? So you want, the failures are more important in some ways than the successes. Because you want to show, I tried this, which is what most ordinary people would try who were skilled in my art, and it failed. And I tried that, and that failed. And I tried this third thing, and that failed as well. And this fourth thing, and it wasn't until the 10th thing that it actually worked. And you want to be able to weave that story in your patent application for the examiner. Because the examiner is going to find all the art that's relevant, and they're going to say, well, no, this is obvious to do. You want to show it's not. And the only way to show that is if you contemporaneously record it. Because believe you me, unless you have an eidetic memory, which are quite rare, you're not going to remember all of this. So start the correct way, the proper way from the very beginning. I don't care if you record it on paper. I don't care if you record it online, though if you record it online, I would make sure it's not necessarily up on Dropbox. You want to, have some secrecy to it. And that's the other thing, keep it secret. You lose foreign protection once you publish enough of the invention so that someone else could make it. Again, lose foreign protection once you publish it. It's the KISS principle, keep it secret. Stupid? Yeah, you don't want to start publishing this and disclosing it. You want to keep it secret to yourself or your co-inventor. And let's say you have a co-inventor. Comes back to, who do I want to partner with? Under the patent law, you have to list the co-inventor, even though now we can list in the name of the companies alone. You want to make sure that you understand who gets what when, if you have a co-inventor. Questions? Since I've sort of blown through this, but I want to give Josh a chance.
Once you file a provisional patent, can you then publish?
I wouldn't. I mean, the provisional is kept secret for a reason. Gives you that year to really see what you're doing. If you're ready to publish, do so, but realize that it will destroy your foreign rights if you don't file a PCT application at the end of the year. So the procedure is file provisional. Within that 1 year date, you file your full-blown US case, and your foreign placeholder, according to the Patent Cooperation Treaty. So if you're not, you have to think again at the very beginning, how much money do you want to spend on this patent? Are you going to manufacture outside the country? Are you going to market outside the country? How important is the patent to that whole philosophy? So it's asking and answering all these questions at the beginning of the process. And it's going to cost twice as much or 3 times as much as you originally think about, because things happen. Patent office is not going to allow you right away. They're going to reject you twice, maybe 3 times. You've got to have the budget to respond to those rejections. And again, you have to have the documentation. You have to have all your failures and then that success. And you have to keep that documentation. If you have published and you've made a blowout, you're really successful, you've sold 1 million units, it's going to be great. You have to tell the patent office that when you get a rejection. You have to have that data, because success matters. The patent office looks at that and says, they've sold 1 million units. We're going to suppose that they wouldn't have sold 1 million units if there hadn't been an unmet need. And if it had been obvious, then, well, there would have been another 1 million units of somebody else's product already done. So you've got to keep everything documented. Really important to be organized and thorough and documented. You do not want somebody coming with the little receipts, as Josh may see a lot.
You can start selling with provisional?
You can.
You can. So
Yeah.
you start the process.
You can, absolutely. But again, at that point, you're going to have to follow up.
Does this all pertain to algorithms as well? Or that type of intellectual property?
Algorithms in and of themselves are not patentable. It's what you do with them that is patentable, and the algorithm is relied upon in the application.
And that's the United States, by the way.
Yeah.
That'll change in Europe.
Yeah, the patent laws are different, very different outside this country. Like business methods, who the hell knows if they're patentable outside? I mean, Europe can't get their mind around it. And unitary patent aside, yeah, Europe may come up with one size fits all patent, and I emphasize may in that sentence. But the laws are different outside the US, so you really need to consult with competent counsel. This is not a do-it-yourselfer, fix the lighting in the ceiling project.
So Amy, well, please, question.
Sorry, so if I was meeting with outside engineers, everybody should sign an NDA?
Oh, they should sign an NDA, but that's not going to protect you from a patent perspective. Because if they're making inventive contributions, you've just invited them into your family.
So what do they need to?
You have to figure out whether they're just doing engineering or whether they're actually making something that is going to add to the inventiveness of your product, which means you really need to consult with competent counsel before you sign. And that's another important fact from everyone. Don't consult with anyone without a contract. If you're talking about intellectual property, especially copyrights, which we haven't discussed here, but the creator owns what they produce. So if you're talking to someone and they're creating something for you that is copyrightable, they own it unless they assign it to you. So anyone who's writing the code for your website, anyone who's doing the graphics for your website, they own it, you don't. Even if you spent $100,000 paying them to set this up, absent an agreement. No, it's very simple. I assign everything I'm doing for you to you. Legal language, we fluff it up.
And you could do that ahead of time.
You have to do that ahead of
You need
time.
to do that ahead of time.
Okay? In some jurisdictions, doing it after the fact, the courts don't like that. They don't like that at all. So you really want to do that at the very beginning of the process. Everybody who's not you want a contract with. Thank you.
Thank you. Good stuff, everyone?
Patents and trademarks are a lot more exciting than taxes, at least in my mind. But I'm going to, Bruce told me it was the Inventors checklist, so I kind of prepared a little checklist format of some of the most common, let's call them issues or pitfalls or things that need to be considered when you're starting a business, a startup, an inventor, anybody that's engaging or beginning an activity that will ultimately, hopefully, lead to a business and a profitable business. These are some of the things that you should think about from a tax, accounting, financial perspective. And a lot of these things, they come up more often than you would think, even though they seem very practical and simple on the surface. I have a checklist here, goes down in a little bit of somewhat of an order, but I want to start with the last item. And the last item is, do I have a great team? And something Amy just said is, couldn't be more true, and that's it. It's a lot cheaper to do it at the beginning than at the end. So one of the things when you're starting a business and you have no money, you have no cash flow yet, you haven't made any sales, these professional services, great attorneys like Amy and Lou, and CPAs and insurance and advisors and consultants, they're costly, yes, of course, but how much of that cost is a really solid investment that's going to save you down the road? And more often than not, investing in a great team, especially just from a simple advisory standpoint, the ability to make a quick phone call when you encounter something you don't know. What you don't know can and will hurt you, especially when it comes to taxes and accounting and things that you tend to put off because you don't feel like dealing with them, you don't know, but you don't have the money to go out and get good counsel. Those are the things that are always going to come back and bite you, especially when you start making money. And like Amy said, it's a lot more costly to do and resolve these things as it goes on. So I would advise you to, if you're thinking or even on the verge of starting a business, just reach out. Start talking to accountants, attorneys. You might get one or two tips and things to do that are just going to set you on the right track, and it won't cost you that much to unwind a mistake that you might make early on had you not reached out to these professionals. So that being said, it's tax time. A lot of you guys may be cramming this week to get your taxes done.
I think it's called an extension.
Extension, right? But a lot of people go on extension. That doesn't necessarily mean, well, it doesn't mean there's an extension to pay. You still have to pay what you owe, but it's an extension to file. We're doing a lot of them right now. At this point, anybody that comes into my office and gives me their tax stuff, they are going on extension. But we'll start, and Amy alluded to this earlier. Do I understand my entity and how it's taxed? How many of you in this room have an entity, have formed an entity for your business, or thinking about forming? How many of you are sole proprietors, acting, as your own personal, it's a couple, LLCs, S corps, C corps, partnerships? Okay, so there you go. So we have a little bit of everybody, and there's 4 basic types of entities, business entities. There's a sole proprietor, the partnership, the LLC, or the corporation, which for tax purposes can be taxed as a C corp or an S corp. All of these entities, except for the C corp, are considered pass-through entities. So the income or losses you get from those business entities flow through to the individual tax, to the individual shareholder or partner or member, and they're taxed at your individual level. The C corp is actually taxed at a corporate level and is separate from your individual tax return. That's the general rule. However, each of these entities have some little quirky things that I want to go over, and I know everybody's got their unique situations, but I just want to give some general highlights as to the differences, maybe some of the benefits and the drawbacks to each of these entities that you might be considering forming. Sole proprietor, the simplest. Starting a business. I didn't do any registration. I'm just going out and I'm operating a business. Yes, you still have to report all your income. You have the opportunity to deduct expenses against that income. But it's very simple. It goes on Schedule C of your 1040. You report your profits, your expenses. And that net profit is subject to income tax and also to self-employment tax. That's a little piece that people sometimes forget when they're doing their projections. You have a partnership. Partnership is a couple of people getting together. We're going to form a business and have a partnership agreement, which, as we heard earlier, is crucial, and it's crucial to iron out all the details and basically draft a divorce agreement before you draft a partnership agreement and enter into business. Your income and losses are determined by the agreement. So how you're taxed is based on what you draw up in that partnership agreement. An LLC is actually what's called a disregarded entity for income tax purposes. The IRS does not recognize an LLC. It's a legal entity, it gives you the legal asset protection, but it's called a disregarded entity. So there's no separate LLC filing. If you're a single member LLC, which means you're the only person in the LLC, which is very common for small business owners that just want to form an LLC, that also goes on your Schedule C, just like you're a sole proprietor. It's basically the same thing. If you have multi-members, typically those multi-members are taxed just like a partnership, where you would file Form 1065, which is the partnership tax return. That would kick out what's called a K1. You would take that K1, which tells you all your income that you have to report then on your personal tax return, and it flows right down into your income tax return, your 1040, which many of you are filing this week.
Josh?
Yes.
The LLC, when you're a sole proprietor, does that then, like an S corp, protect you in terms of the corporate protections that exist?
Yeah, well, that's exactly it. You know, an LLC or a corporation. You know, as far as I know, I don't know if there's any difference in the legal protection, but I'm pretty sure they're separate entities, and they give you that asset protection where you're taking your assets of your business and separating them from your your personal.
Yeah, there's no legal difference.
There's no legal difference, and that's the main reason why you form an entity, business entity. Otherwise, everybody would be a sole proprietor. But then again, you run that risk where your personal assets are kind of intermingled with your business assets, and somebody could sue you for something you did in your business, and then they go after you personal. And that's really the yes.
Yeah, I may be premature question, but why then make yourself a corporation rather than an LLC? Wouldn't an LLC be simpler?
Well, there's a couple of things I'm going to get into.
Okay.
I'm going to get into. Actually, it's my next topic.
Right.
Okay. So there's so we spoke about the LLC, which is kind of like a partnership. There's also a corporation, which can be a C corp, which is just a typical corporation. You know, you buy stock in IBM. IBM's a C corp. Then there's what's called an S corp, which is a special election that you make for tax purposes to be taxed as a pass-through entity. And the reason that you would make this election is to avoid what's called double taxation. I don't know if you've heard of what double taxation is, but that's the reason. It's almost always more beneficial to be taxed as an entity, because typically your individual tax rates, even though after the last tax law, in some cases they might be higher than the corporate tax rates, but the individual tax rates tend to be lower than the corporate tax rate, and also you avoid the double taxation. So when you pull out the money in the form of dividends on a C corp, it's taxed again. So you're taxed at the corporate level, then you're pulling out money, you're paying yourself dividends, 15%, 20% now tax on dividends. So you're getting hit twice. So that's one of the main reasons. Now the biggest difference between an S corp and an LLC, there's two main differences. An LLC is very, very flexible, especially for a startup business. You can pull money in, you can pull money out, you can have multiple partners, multiple members. You can get 5%, I can get 10%. You can always pick and choose and what the allocation of income is at any time. You can change your operating agreement, and you can adapt. Also, an LLC is very flexible when you're dealing with other investors. You're trying to get investors in. Anybody can invest in an LLC. You can spin off an LLC very easily. It's a very portable entity structure. The other thing with an LLC is it's a little bit more costly to form than a corp. So some people initially are kind of say, I just want to form an entity. The cheapest one is an S corp. It's a couple $100 to file and register. I'm going to form an S corp. LLC, there's attorney's fees to get an operating agreement together. There's what's called the Crane's Law, which forces you to advertise your LLC in 2 newspapers, I believe. And in New York, it depends on kind of where you're forming that LLC. And in New York City, I believe it's probably the most costly place in the state to form. So, you know, while it's not overly expensive, you know, somebody with no money forming a company, you know, might not want to pony up that cash initially.
You do not have the option of choosing where you want to publish. The state does it for you. If you're in New York County, the cost for publication of an LLC or an LLP can be as much as $1,700. And that's on top of the other fees that the government charges. So this is a known issue with respect to New York, and especially New York City. To form here is much more expensive than to form in any other state. However, you cannot get away with forming in Delaware if you live and work and run your business out of New York, because yes, you've got a lovely Delaware company for a couple of $100, you still have to publish here. You still have to register here as a foreign entity doing business in New York.
A lot of people will tell you, you know, I don't know, maybe they read articles or things like that where, you know, they'll tell you, file in Delaware, you know, register your business in Delaware. There's no state taxes in Delaware, so you don't have to pay state taxes. It's a bunch of bogus. You're taxed on where you're doing business. It's pretty plain and simple. Actually, you'll be taxed more because Delaware has, you know, a tax on the stock that you owe. You know, based on the number of shares that you own, they tax you on that. And it's just, you know, it's just a pain. If you're doing business in New York, register in New York. It keeps it simpler and it's better. The reason that you'll see the Fortune 500 companies register in Delaware and Nevada, typically for legal liability protection, for interstate commerce, and for board of directors protection. That seems to be the reason that you see the bigger companies register in those states, because, you know, they're dealing with a whole host of different issues, and if it gets to that point, it's a good thing, and then you can, you know, deal with it if you want to reorganize your business.
If you have two principals who are starting up a business, and one lives in New York and one lives in New Jersey.
That's trouble right there.
Yeah, right. Yeah.
Is it a flip of a coin? Is there, you know, how do you determine?
Well, it's based on where you're doing business. So, I don't know if in this scenario you would be doing business in one state, one or the other,
Let's say they both work out of their home office.
Both?
And
okay, so if you're doing business in both, then you would be subject to tax in both states. You wouldn't be paying double tax because that's what's called, you know, credits, and you get credits for taxes paid in other states. But you know, it's a good example because it is where you're doing business, and there's, on a business tax return, there's allocations and apportionments based on the receipts and the sales and the payroll in each entity, and each state is different, and each state has different formulas. So, you know, yes.
What about online sales tax?
I'm gonna try to stay away from sales tax. A, because I'm not a sales tax expert, and B, because it's probably the most complicated you know, type of tax out there, and there are people that specialize in it. But I will say it's on my list. If you look at the second section, am I subject to withholding and remitting sales tax? The best thing you could do is investigate. Just think about it and investigate. And what are you selling? What states are you doing businesses? Make some phone calls. Call this New York State, because I get sales tax questions all the time. And you know what I do? I say, I'll get back to you. I call up New York State. They're very good. They really are. They answer the phone. They know the specifics, and they'll tell you right off the bat, you know, if something's sales tax is subject to sales tax, and if you have to register to withhold and remit sales tax. And then I get back to my client and I say, I spoke to New York State, this is what they told me. And I always advise my clients, even if they don't have sales sales that are subject to sales tax, to still file 0 sales tax returns, because it imposes the statute, which is 3 years. So let's say New York State wants to examine your business, and they come in, you know, you've been in business for 15 years, you haven't been you know, dealing with sales tax, because, you know, you sell a product that's not subject to sales tax. They might come in and say, you know what, we're gonna go back to the beginning of time and dig into your business. Well, if you filed sales tax returns, even if they were 0, they'd only go back 3 years. So it's a good safe protection, and it's a simple form to file. You can actually file a zero sales tax return online, and it takes all of 3 seconds, you know, every single year. So that's my sales tax advice. Do you have any more sales tax advice? I know somebody that deals with it. You know, it's not my area of expertise, nor do I want it to be. And every state is different. Every state, that's the other thing about it. Every state has different rules, and they come up with you know, different definitions for what's taxable in their state. Okay, I guess moving on. We spoke about another big thing about LLC, difference between LLC and S corp, because that seems to be the two most common small business entities that are being formed. And this is actually a big one, and one of those ones that can come back to bite you after. There's something on S corps that are called basis. You need it's also in LLCs, but more prevalent in S corps. You need basis in your entity, basically your investment and your income that you earn, to be able to deduct losses. You know, a lot of people think that you know, they lost money, they could just deduct it against their other income. It's not necessarily true. A big reason for that is a lot of people borrow money to fund their business initially. In an S corp, a loan that you take out does not give you basis. So let's say you started out with $0. You didn't invest a dime into your business. You know, somebody gives you $100,000 in a loan, that doesn't give you basis. So even if you lose $100,000 that first year because you lost all the money you got in a loan, you can't then go, even though you're the 100% shareholder, you can't then go deduct that on your personal tax return because you have no basis. An LLC, if you personally guarantee that loan, it's called you know, a recourse liability, where you actually get the basis and you can deduct that loss. So it's a big deal, and one of those things that actually a lot of CPAs you know, don't even pay attention to that. We've seen that where we would get somebody's return, a client for the first time, and we would look at it. They said, "Wait, they deducted this loss. They had no basis, and you know, somebody botched something, and then you know, it's all sorts of stuff that you got to undo." So that's a key area. An S corp also, if you're making money, if you're taking a profit, making a profit, you have to pay yourself as the shareholder officer a reasonable salary. Now, why do you have to pay yourself a reasonable salary? Because the IRS wants to collect their self-employment tax portion. You know, otherwise you're not paying self-employment tax. You're just being taxed on the S corporation earnings. An LLC, like I said, is all self-employment income. You know, especially a single-member LLC, close to your Schedule C. That net profit is going to be income taxed and taxed, you know, for self-employment. So that's a big thing. You know, that's I believe last year we had that payroll tax holiday, but now you're looking at 15%. And that's the same tax that if you were working for a corporation and you're getting, you know, a paycheck with withholdings, you know, you give you a $100 paycheck and you come home with 10, you know, all those little taxes, the FICA, the Medicare that they're deducting, you still got to pay those, even though you're not, you know, collecting your, you know, your paycheck like you normally would. So that's a big deal. And an S corp forces you to take a salary, and the IRS does not want you to make that salary $10,000 if you're making $100,000 of profit. They want to make, they want to say, hey, wait, no, this is what you do for you know, a living. You know, I want that salary to be closer to $100,000 so I could get my FICA and my Medicare out of it. So there's kind of a balancing act with how much you should be taking as a salary when you're an S corp officer shareholder.
What if that varies? Maybe 1 year you make $100,000, and the next year you make
It varies.
so each year you get a different salary?
Yeah, the accounting answer is it depends. It varies. It's you know, it's supposed to be, the definition is reasonable compensation. If you were to get that, if you were not to be involved, if you were to go get the same job or do the same job somewhere else, you know, what would you get paid in that circumstance? That's kind of like the rule of thumb. And, you know, there's all sorts of interpretations of that rule of thumb, but, you know, it's one of those things that can come back, to bite you. They can say, look, you claimed all this income, you never paid self-employment tax on it, we want our self-employment tax.
That's your favorite expression, Josh. It's going to bite you. And I think that's like the
It's
theme
good.
maybe.
All this stuff can bite you, yes.
I was curious to know if you were going to cover or just discuss the difference between sales revenue, if an inventor intends to commercialize, and royalty revenue, if you intend to license and just collect the checks. Is there any difference in that type of revenue?
Typically,
other than one being easier?
there is. It depends. Again, it depends. It depends on the entity and your business. So, for example, if you are, let's say you're one of these flow-through entities, right? That you have a partnership, an S corp, and that information then flows down to your personal tax return, right? Which is most of you. The royalty revenue and your business revenue are reported differently on your tax return, and in most cases, if it's one and the same, it probably would not make a difference, being that that you can deduct your same business expenses against that same income. However, there's something called passive activity rules, where the IRS deems you not to be necessarily active and engaged in a business, and there's very specific rules on that. Then you might not be able to deduct losses, against that income. So, if you're just getting income, great. It's all going to be taxable. But let's say you have, you have royalties that's kind of separate from you made a product years ago and you're getting residual royalties to it, and now you have, a separate business activity that's not a passive activity, but it's an active activity. You might not be able to offset them against each other. So that's, it's one of those, it's one of those quirky things that, you can't figure out on your own just by reading the tax returns.
Josh?
Yes.
And that's why you really want your lawyer and your accountant to work together. Something we always try to have done, because we can structure the license agreement so that you actually have obligations that you need to fulfill with respect to that royalty income. It's essential, indeed, with trademark licenses. If you're licensing your brand, then you actually have a legal obligation to maintain quality control. And it is not a legal fiction. It is a real live obligation. So
it's interesting,
you want to be able to work together with the accountant so that the legal agreement is structured properly to maximize or minimize your tax burden.
It's interesting that you brought that question up, because this is totally a little bit unrelated, but I have a client that she is, I guess, the heir to she inherited some sort of residual royalty from Paramount Pictures, from like the rights to Bridge on the River Choir, one of those famous movies, and she gets this royalty income every year, and we were reporting it a certain way, get a notice from the IRS saying, well, that's subject to self-employment income because it's on, this line. So we had a correspondence back and forth, explaining what it was, and, the result of it was, okay, no harm, no foul, we resolved it, but now we have Paramount having to issue their 1099 to us in a different way. So it does, there can be things that are triggered when you're dealing with royalties, because the royalties have special reporting on your tax return.
Josh, if I may, 5 minutes,
Okay.
maybe I'll cover a couple more things, or some questions also, because then we have pitching panel, and we have a great pitching panel presenter tonight. So,
yeah, I'm just going to go through some of the highlights of some of the other things. Like I said, sales tax, payroll tax is a big one. You have to file your payroll taxes, your W-2s, your 1099s, if you pay vendors with more than $600. Books and records, that's the biggest pitfall. People just don't maintain books and records, and you might think it's okay, and you might think you're making money, but how do you know? How do you know if you're what your business is doing if you don't maintain books and records? if I ask you what's your profit, and you just, well, I think it's, X, or what's your basis for that? I mean, how could you really manage your business? Forget about the accounting and the tax side of it. How could you manage your business and your cash flow, which is my next segment, without maintaining good books and records? Managing my cash flow effectively, that's the number one reason why small businesses go out of business, is they have no cash. Are you collecting what you're selling? Are you granting credit? Are you, spending more than you're making? These are the things that you need to do as a business owner. If you don't understand your tax situation because you haven't hired an accountant to let you know and educate you, then you might be spending your tax money, and then April 15th comes and you get hit with a big bill, and you didn't realize it, and you have no more money to pay the government. So that could put you out of business. Let's see. And we talked about financing a little bit. You need proper agreements in place with all your financing. There's so many different types, especially when you're small businesses and you're dealing with angel investors and venture capitals and convertible notes and options, and a lot of these new financing arrangements, they try to treat these small businesses like they're public companies even before they have started their entities. So there's a lot of complicated stuff, and more often than not, the more complicated it is, at the outset, the more complicated it becomes when you're dealing with tax returns. I can't tell you the number of tax returns that I do for entities that make no money, have no money, but they take hours and they're very costly to do because they have all these complicated agreements and arrangements going. Don't enter into something if you don't know what it is and what the impacts are going to be. Yes.
And let me add, and I know you had a session on this, but it's equally as important if your investment is from friends and family. Mm-hmm. You want to document those investments.
Probably more important.
Mm-hmm.
It's probably.
Yeah. You want to have those properly documented so everyone again is on the same page, understanding when they're going to get paid back, if they're going to get paid back. You do not want to destroy family relationships because people had one perception and you had another.
A lot of times, businesses, I guess I'm closing this, businesses enter into transactions throughout the year. And look, you guys, one of the other reasons, and the main reason, is to have this great team around you and to hire a great accountants, great attorneys, great advisors, is leave that stuff to the professionals. You don't have enough time to educate yourself into these matters that are very complicated and changing every day. You need to run your business, grow your business, and do the things that you do well. And it's a great investment to hire the professional to handle all the things and the gaps that you can't handle. But the one thing that I'll say is a lot of businesses enter into transactions throughout the year that they seem ordinary at the time and they seem harmless, but they do not advise their team, their lawyers and their accountants about what they're doing. And then you find out later, a transaction that they entered into was either, very, very poor decision from a legal perspective, from a tax perspective, from a planning. These are the things that you should be consulting with your team. And if you don't have a team, then who are you going to consult with? So, back to point one is if you're entering into business or you have a business, you need a great team because it's only going to help you. And don't get scared off by the initial costs. And if you have a great business and a great idea, a great team of advisors and professionals will work with you if they believe in your idea also. I would love to get involved with businesses that I believe have bright futures. Even if right now maybe they can't pony up my standard rates, maybe I'll work with them because I believe in them, and it never hurts to ask. A 15-minute phone call could really go a long way.
And as we always like to say, ask for referrals, ask friends and family who they use, but don't be afraid to interview an accountant or an attorney. An accountant or attorney should be willing to give you the time of day to answer your questions, and if they're standoffish and arrogant, leave immediately. I don't think either of these two people up here are standoffish and arrogant. With that, Josh, thank you very much. Really appreciate it.